Welcome back, everyone, to Open Line. Our guest, Barbara Boone McGinnis with McGinnis. We were talking about elder law, and we spent some time talking about just the cost of nursing home care and that kind of thing. How do you deal with that? How do you prepare for that? Especially if you have a loved one, an aging loved one, you know, what are some of the things you should do? In this segment, I want to talk about wills, which is always interesting. But there's some visitation guideline changes, right, that are coming in, I guess, at nursing homes and that kind of thing. It's been a tough time with COVID. What are you aware of? Kind of what are we seeing right now?
You know, visitation to nursing homes and assisted livings over the past year have just been heartbreaking. And it's also been confusing. And that between the heartbreak and the confusion has led to just a lot of hard feelings between people on the outside world for the folks running these facilities. The guidelines are ever changing. And here's one thing that people should understand that could be somewhat helpful. Assisted living and nursing homes, different set of licensure, meaning different set of visitation requirements or restrictions. So skilled nursing facilities, nursing homes, they have not only state regulations, they also have federal regulations. And those federal regulations come from the Center of Medicare and Medicaid Services, CMS. So you may have heard of that. They actually the CMS set the rules for visitation. They leave some ambiguity, wiggle room for facilities to interpret and make them their own, but it tends to make visitation in nursing facilities more restrictive than visitation in assisted living facilities. So from the get-go, people often confuse assisted living and skilled nursing facilities. They think they're all just nursing homes. They're not. Assisted living are designed just to provide assistance with activities of daily living, and they are purely state regulated. The regulations are much fewer because of that, and they get more flexibility in designing visitation. So you might see more open visitation in assisted living, where you just walk right in and they don't take your temperature or make you sign a waiver or make you stand at the window or anything anymore. So those visitation guidelines, I think, are going to continue to relax, but they're going to but more slowly for skilled nursing facilities than you'll find in assisted living. When in doubt, just call ahead and ask, because it also depends somewhat about the rate of COVID infections in your county. So hence a large chain like NHC, National Healthcare Company, you may see different visitation guidelines throughout the state because of what's going on county to county.
Yeah, that's interesting. Definitely call. Oh, yeah. And it makes sense. There would be this confusion because it's different at a nursing home than at an assisted living facility. And people may think, well, at this assisted living facility, it's this. So why can't I do it over at this facility? And they're just separate. There's different regulation there. All right, that is helpful. Let's go to the phones. Let's go to Francesca. Hello, Francesca?
Yes, I'm here.
Hi, go right ahead. What's on your mind?
I would like to know, how often is the filial responsibility law used in Tennessee?
Now, do you know what that is?
I do. Filial responsibility laws, they relate to a child being responsible for a parent's debt. And I do think there is some sort of vague law in Tennessee. Not only have I never seen it enforced, I don't know anyone that has seen it enforced. You would probably have to do some sort of historical search to see the last time that that was enforced. There is some case law in Pennsylvania. That's the closest thing that I can tell you about that anybody has been held responsible for a parent's medical debt. Just don't sign the documents, the admission papers, personally accepting personal responsibility or guaranteeing payment. If you're having to sign a parent or a loved one into a facility and you're using power of attorney authority, sign as power of attorney. If you're using conservatorship authority, sign as conservator. In those instances, you are only promising the facility that as a fiduciary of that new resident, you are going to use their money appropriately to help pay for their care. You're not accepting personal liability and responsibility for payment. Does that help, Francesca?
Wow. Francesca, I think that's a great question. I had to put her on hold. I can't find her, but
okay.
That's a great question. And so it does bring up, your answer kind of brings up the follow-up question of, does it sometimes happen, okay, if I'm desperate to get someone in a facility, we haven't done the power of attorney, I sign for it, am I then, if I did sign somehow, am I on the hook for the debt should my, poor mom or dad pass away? Does that happen?
I can see where it could happen. If you're signing as not, that you're signing and accepting responsibility for payment, yeah, you gotta be careful what you read. It's a big old packet of information that when you're admitting someone into a healthcare facility. So you have to be careful about what capacity you are signing in.
Very interesting. And then the other aspect of that question that I find interesting, okay, say it has nothing to do with medical debt. Medical debt would be the most likely scenario. But, say
right.
The parent just had a lot of debt for whatever reason, then the parent dies. That debt is not passed on ever, really.
No, that debt is not passed on. Now, the estate incurs the debt. The estate of the decedent would accept the debt. If there are no assets in the estate to satisfy creditors, then there is a method of prorating. So let's say there's a little money, but not enough to pay off all of the debtors or the creditors there. Then there is statutorily, there is a way that you prorate the debt and who takes priority in those situations. It's still a time to seek legal counsel to get that right. If there's just no money and they die with debt, well, that's terrible. But then it doesn't pass on to the beneficiaries or the heirs of the estate.
Which, yeah, okay, that's good. All right, and then let's talk about wills. Why wills are so fascinating. What do people get wrong about wills? What do people get right about wills? I mean, what's kind of your baseline sort of educational statement on wills, and what do people get wrong often?
I think there's a lot that people get wrong, have misconceptions about wills. One thing for sure, I hear it frequently, is that people think if they have a will, they do not have to go to probate. I think it's because we've done such a good job of just hammering home this notion that you need a will, you need a will. And you do need a will as an adult, but you need a will to express your intent and desires about your disposition of assets. How do you want your money distributed or your possessions distributed at your death? If you do not express that in the term of a will or a trust, well, then the state has what they call an intestate, meaning without a will, succession plan. So they have a plan for your estate if you don't have a plan. But wills are actually designed to be probated. They only have authority once they've been admitted to the probate court, accepted by the judge. And that is when the executor is granted letters of testamentary, giving them authority to act on the estate of the decedent. So people think wills mean I don't have to go to probate, which is not the case. Wills are designed to go to probate. And people often come in and say, I'm the executor of my dad's estate. And I say, well, that's great. Is your dad dead? And they say, no, my dad's not dead. Well, then you have nothing. You have a piece of paper. You have a future duty to your father's estate, but you have nothing currently in terms of authority for your father.
Wow, that's interesting. Yeah, so just because you're named executor, that doesn't give you any authority until until there's something with the will, which is after he passes away.
Right.
But people maybe don't get that. All right, that's interesting. Let's take Stephanie's call. We'll continue to talk about wills here in a moment. All right, Stephanie, are you there? Go right ahead.
Yes.
Stephanie?
Yes.
Go right ahead. What's on your mind?
I would like to know if I'm a caregiver for my parent, and I would like to know how I proceed with applying for Medicaid if my brother has used all of my mom's assets and she's indigent and she needs total care.
Okay, that's a great question.
Oh. Okay. So there's lots in that scenario, right? Stephanie is taking care of her mom, and now mom no longer has assets. And here it starts getting fed because brothers use them. His brother used them with mom's permission, where mom has gifted that money, or his brother misused fiduciary authority. Is there something that needs to be investigated or reported to the police here, or so that's one set of issues. She didn't really ask me about that, though. She asked me, how do I apply for Medicaid? Mom is now depleted of assets, but it's not really spent down. TennCare, Medicaid in Tennessee, has a hardship waiver. So there is an outside chance that you could apply for whether the home and community-based program or an institutionalized assistance through TennCare, and you apply with hardship. You just go ahead and say, the money's all gone, the money is gone because my brothers used it. Mom did or did not gift it. Now you have to be clear about that. If mom gifted it, she's probably not going to get any assistance for the 5 years. But if mom didn't gift it, there is a chance that you can get it forgiven, the gift, based on hardship. The money's gone, it's not coming back. It wasn't mom's fault, the money's gone. Don't penalize her. She needs the care and assistance through the Medicaid program. It can happen. I have seen it happen.
Wow. So that is, and I would hope this family doesn't need, a police investigation here. What they need is just help for the mom. And so, assuming the brother, I'm sure there's family tension. He maybe was caring for the mom, and now the money's gone. Let's assume, maybe the sister disagrees with some decisions, but for the most part, the brother was doing the best he could. It's not a criminal thing. But now there's just no money. Yeah. There are things that are open in this case, right? There's several things that can be done.
Mm-hmm. Mm-hmm. Yeah.
And so, all right, well, that's good. All right, that's a great question. And is there anything else you want to add to that? Any other thoughts? Because I bet a lot of people have that.
Yeah, I was just going to say, go ahead and apply. If you're talking about a home and community-based program, you apply through the Greater Nashville Area Agency on your AAAD is what I'm trying. Ask you a number of screening questions. Just tell them you want mom to be assessed for the benefit and that she financially qualifies, because those screening questions are just that. They're trying to decide whether or not mom needs to be assessed for the benefit. Once you get the assessment initiated and you actually apply for benefits, that's when you give full disclosure. You're completely transparent with what's happened with the assets, but you don't want to cut off the chance of getting an assessment initiated for her benefit to where you're even talking to the right people.
Okay. All right. Stephanie, thank you for that call. I'm going to take Mark, even though we're supposed to go to break. I'm going to take Mark right now. Hello, Mark.
How you doing?
Go right ahead. What's on your mind?
I got an 84-year-old auntie I take care of, look out on nephew, and she got a problem of hearing, and she won't go to the doctor. And, you know, you talk to her, she'll jump on another subject like she don't understand. If anything legal, I can force her to see the doctor.
So you have an 84-year-old aunt, and she needs to go to the doctor for, it sounds like, her hearing, and she's refusing to go. She doesn't want to go. So this is, all right, this is a tough situation. What do you recommend for somebody that's trying to care for a loved one like this?
Well, having a hearing eval done is very, very important. We do have to be able to hear it for communication. It impacts isolation and social isolation. It can mimic dementia because, you know, we're answering questions incorrectly. And my mom was terribly hard of hearing, and she'd go to the doctor or go to the hospital. I'd always say, she does not have dementia. She's very hearing, because she would answer off. She'd say weird things. So anyway, lots of reasons why we need to be able to hear. She may be afraid of the cost of the evaluation. But you know where you can get hearing evals done? You can get hearing evals done at Sam's. It looks very non-threatening. If that's all she needs, or if that's the primary thing you're worried about, some of these hearing eval centers could be done in a non-medical setting. There's clinics that are very homey, audiology clinics that can be done. Make it an outing, make it fun, and try to show her the reward of what better hearing could do for her. And
there are major benefits, because I don't know if it's cheap fixes, but there are fixes. I mean, there are things that can be done that would really improve the quality of her life. Right, they really are. All right, Mark, good luck. That's a tough situation. Good luck to you. And I appreciate that call. All right, we're going to take a break. We'll come back. We'll continue to talk about wills. We'll also talk about trusts when we come back. So we'll take a break. We'll be back right after this.